Start. As per contents of FIR, petitioner was duly nominated with specific role of causing firearm injury on person of the complainant. Full stop. Medical evidence is available on the record, which also supports the prosecution version. Full stop. Allegedly, the petitioner made three fire shoot on the person of the complainant, during investigation. Pistol also recovered from possession of the petitioner. Full stop. The learned counsel for the petitioner argued that co-accused has been granted post-stress bail, so present petitioner is entitled for concession of bail on the basis of rule of consistency. Full stop. The roles ascribed to the present petitioner and his co-accused are somewhat on different footage, present petitioner allegedly caused firearm injuries, so principle of rule of consistency does not make out. Full stop. There is sufficient material available on the record to connect the accused with the alleged offense for opening of murderous attack upon the complainant. Full stop. This court believes that the accused petitioner has committed non-bailable offense, and the case of petitioner also does not fall within ambit of further inquiry. Full stop. In view of above discussion, petitioner Maruf Khan is not entitled to the concession of post-stress bail, therefore, application in hand stands dismissed. Para. Perusal of record further reveals that instant case was registered on the application of complainant, alleging therein that accused committed theft and neighbor witnessed the said occurrence, the name of witnesses were not mentioned, there is delay of 5 days in registration of FIR, only amount was recovered, the accused admittedly, was living in a joint house with the complainant, the taking of dowry articles at daytime also creates doubts in prosecution story, especially when both were residing in a joint house. Full stop. The accused is behind the bar more than 1 month, the question of recovered articles shall be determined after recording of evidence, at this stage the person of petitioner is no more required by the local police and his confinement would not serve any useful purpose. Full stop. The offences does not fall in the ambit of property clause of section 497 CRPC. The cause of accused is one of fire for further inquiry. Full stop. Perusal of record further reveals that the petitioner was driving a vehicle, who was challaned, later on, he produced his driving license, on its verification, it was found bogus. Full stop. The accused petitioner took plea that his license is valid and traffic police got registered this false and fictitious case against him. Full stop. On 4/8/2017, again the license was sent to the in charge driving officer Lahore, report was received to the effect that license is bogus. Full stop. The accused admitted possession of the said license being driver of vehicle. Full stop. The accused is nominated and the circumstances of this case fully connect the accused with the alleged crime. Full stop. No doubt, offense does not fall in the ambit of property clause of section 497 CRPC, but it cannot be made a sound ground for post-stress bail. Full stop. The case of accused also does not fall in the ambit of property clause because a police official, while performing his official duty, apprehended the accused with red-handed. Full stop. Perusal of record shows that accused petitioner is nominated in the FIR with the specific role of handing over the check, handing over the check to the complainant. Full stop. Said check was subsequently dishonored by the bank for want of requisite amount in the account. Full stop. The issuance of check has not been denied. Rather, in bail application, it was averred that the check is outcome of the business transaction, full stop. Material available on record prima facie connects the accused oblique petitioner with the commission of alleged offence, full stop. Deeper appreciation of evidence is neither permissible nor warranted by the law at bail stage. Full stop. Accused oblique petitioner has defrauded the complainant by issuing a bogus check. Full stop. No malafide or ill will appears on part of complainant to falsely involve the accused petitioner in the present case. Full stop. Although the offence does not fall within impropriety clause, but grant of bail in such like cases is not a rule of universal application, and each case has to be decided on its own facts and circumstances. Full stop.